everyone. Welcome to IAML's alert on the new ADA and GINA wellness regulations. We're joined today by Brooke Colaizzi from Sherman & Howard. Since she joined Sherman & Howard in 2003, Brooke has litigated claims under Title VII, the ADA, the ADEA, and the FMLA. Brooke is the perfect person to inform us on these new regulations as she counsels employers on all aspects of the employment relationship, including contracts, workplace policies, employee relations, wage and hour issues, leave laws, wellness programs, independent contractors, and covenants not to compete. Thank you so much, Brooke, for joining us today. Please start when you're ready.
Thank you, Mike, and hello, everyone. To say that healthcare costs are a hot topic these days is somewhat of an understatement. Employers have used wellness programs for many years as a way of trying to combat the high cost of healthcare for their employees. And they also use them for other reasons, increase in productivity, increase in morale, sense of team building. Wellness programs just make a lot of practical sense for a lot of employers. But one thing that we have known for several years is that the Equal Employment Opportunity Commission, the federal agency that is responsible for enforcing the federal employment anti-discrimination laws, has not been a fan of wellness programs. And in the last few years, they have sued several employers about their wellness programs, alleging that the programs violated either the Americans with Disabilities Act or the Genetic Information Non-Discrimination Act, or GINA. While we've known that the EEOC isn't a fan, we also have not had any guidance to understand exactly what the EEOC has found offensive about these programs until now. In April of 2015, the EEOC issued a notice of proposed rulemaking addressing the interaction of wellness programs with the ADA and GINA, and final regulations were published in the Federal Register this past Monday, May 16th. I'd like to walk through the key points of those regulations with you. Before we do that, it probably makes sense to understand what the EEOC considers to be a wellness program. They define a wellness program as a program that is reasonably designed to promote health or to prevent disease. That's a very broad definition. It can cover everything from educational programs to smoking cessation programs, weight loss challenges, all the way up to complicated and multi-tiered wellness programs involving health risk assessments and biometric screenings. But the key point to remember is that the ADA and the GINA requires that a wellness program actually have a health-related purpose. Now, with respect to the ADA, the wellness programs that implicate that statute are those that do one of two things. They either have a component to them that is a medical examination, or they have a component that asks questions that are considered disability-related inquiries. And that's because the ADA generally prohibits employers from doing those types of things and making those inquiries with respect to their employees. Wellness programs are an exception to that general prohibition so long as they are voluntary. And a key part of the regulations is understanding for the first time what the EEOC considers to be voluntary. With respect to GINA, GINA implicates wellness programs that have a component related to genetic information. And I'll go through here shortly a little bit more information about what that genetic information entails. Now, with respect to the ADA, the regulations are fairly broad with respect to addressing very many facets of wellness programs. With respect to GINA, the GINA regulations address a very, very specific circumstance, and that circumstance is one in which an employee's spouse is participating in a wellness program, and as part of that wellness program, they are asked to provide information about their health status. So it's important to keep in mind that when we're talking about GINA, we're talking about that very specific circumstance, and I'll describe that in a little bit more detail here in just a moment. With respect to the ADA, the key question, or the point of most contention over the last few years with respect to this whole issue of being voluntary, is whether or not employers are permitted to use incentives or penalties to encourage employees to participate in wellness programs. As you can imagine, incentives and penalties are a pretty powerful tool to maximize participation, and it's also the part that the EEOC considered to be potentially coercive. So this whole issue of penalties and incentives is really at the core of these regulations. And the EEOC has concluded that with respect to the ADA, limited incentives and penalties can be used by employers without violating this voluntary requirement. of the statute. With respect to GINA, as I mentioned before, GINA generally prohibits employers from requesting the genetic information of their employees. GINA is an anti-discrimination statute patterned after Title VII. Like the ADA, it has an exception to that general prohibition for wellness programs that are part of health or genetic services offered by the employer. Now, we need to make sure we understand what genetic information is. Genetic information is defined as the genetic tests of the employee, the genetic tests of the employee's family members, or, and here comes the mouthful, the manifestation of a disease or disorder in a family member of the employee, which is a fancy way of saying family medical history. And the GINA regulations focus on that very specific instance in which a spouse is asked questions about his or her current or past health status. A spouse is considered to be a family member under GINA, which seems a bit odd because obviously in the vast majority of cases there's absolutely no genetic connection whatsoever between an employee and his or her spouse. And that's why this particular issue came up. Can employers in fact give incentives when a spouse is the one providing the information on the theory that they're not going to discriminate against an employee when it's not the employee's genetic information that's being discussed? Like the ADA, the EUC decided that with respect to GINA, limited incentives are permissible when the spouse is giving information related to current or past health status. It's just that family medical history piece that is allowed with respect to incentives. Let's dive into a little bit more of the detail with respect to these incentives. Both the ADA and the GINA regulations adopt this 30% threshold for incentives or penalties. And what the regulations say is that no incentive or penalty can amount to more than 30% of the cost of employee-only coverage. Now, it's important to realize that a year ago when the proposed regulations were first issued, they with respect to the incentives, addressed only wellness programs that were part of group health plans. So that's why we have this reference to employee-only coverage. In the final regulations, the EUC changed course a bit and has now indicated that these incentive limitations apply to all wellness programs, regardless of whether they're part of a group health plan or independent. Now, the 30% is calculated in a slightly different way depending on what the health insurance situation is in your organization. If you don't offer health insurance at all, you calculate it a certain way. If you have multiple health plans, you calculate it a certain way. If you have one health plan, you calculate it a different way. So I'll refer you to the regulations with respect to what your organization situation is so that you can make sure that you have a good idea of what that 30% means for you. That 30% is roughly equivalent to what the Affordable Care Act allows with respect to incentives, and is also very similar to the incentives that are permitted under HIPAA. So the EEOC did make some attempt at uniformity in coming up with these requirements. Now, a couple of other issues with respect to these incentives, and I mentioned this a moment ago. Under GINA, again, these incentives are permitted only in that very specific circumstance related to a spouse. An employer cannot offer incentives for the employee to provide information about his or her own genetic information, nor can they ask a spouse about the spouse's genetic tests, and nor can they ask for the genetic information related to an employee's child, which makes sense in the sense that a child is going to have some genetic connection to the employee, but also note that that prohibition also extends to adopted children, even though there's no genetic connection with an adopted child. So just keep in mind that it's a very narrow circumstance under GINA in which you can offer these incentives. And it's also important to keep in mind that although the incentives have been the core of this voluntary issue for the last few years, there are other aspects to it that the EEOC insists upon for these wellness programs to pass muster. Employers cannot condition access to health benefits or to certain packages of benefits, either on participation in a wellness program, or the provision of genetic information, or in this case, the spouse providing the genetic information. The employer is required to give a notice both to the employee and to any participating spouse identifying the type of information that's being collected that is implicated by the statute, so the disability-related information and the genetic information. What information is being collected, how it's going to be used, how it is going to be kept confidential, and the safeguards in place for maintaining that confidentiality. And as kind of a side note with respect to confidentiality, despite these incentives, an employer cannot require a participant in a wellness program to waive any of the confidentiality provisions or to agree to uses or transfers or sales of that information other than the use of that information for purposes of forwarding the goals of the wellness program. A couple of more technical side notes that came out as a result of these regulations for those of you who may be involved in very detailed wellness programs or have significant experience with them. One issue that has come up is this whole issue of whether employees can simply say, I want to participate in the wellness program, I want the incentive, or I want to avoid the penalty, but I don't want to give you this information. I want to simply give you a note from my doctor saying I'm under a doctor's care and we're addressing any potential health issues. And the EEOC actually did the employer a favor here by saying that's not required. An employer is not required to simply accept a doctor's note like that for purposes of qualifying for an incentive or avoiding a penalty. The employer can require that the individual provide the information requested in order to achieve the incentive or avoid the penalty, provided that it's otherwise legal under the statute. And finally, if any of you have been following the federal cases with respect to wellness programs, you may be aware of a couple of courts that have addressed the issue of wellness programs as falling within the insurance safe harbor provision of the ADA, which essentially allows the sponsor of health plans to use incentives, use premium changes and things like that in addressing risk, evaluating how much premium should be, can they be reduced in certain circumstances, and those types of things. The EEOC doesn't like those opinions and has come out and said that they disagree with them and believe that they are wrongly decided. And this is an issue that we may see some additional litigation on in the future, because at minimum the courts are going to have to decide whether the EEOC's interpretation here is entitled to any kind of judicial deference. Keep in mind, as has always been the case with wellness programs, as an employer you're entitled to aggregate data only. You are not allowed to receive any protected information, so genetic information or disability-related information that has identifying factors with it that would identify to you from which employee it came. And also, the ADA, although the core of this regulation involves what employers can ask employees to provide, the reasonable accommodation provision of the ADA still applies to wellness programs. So if you have a wellness program and you have people who want to participate that cannot, for some reason related to a disability, you still have to provide reasonable accommodation in your program to allow them to fully participate and to fully qualify for any incentives or to fully qualify for the opportunity to avoid any penalties associated with the program. And of course, the most common incentive, the one used most frequently by employers because it has the most impact, is varying the amount of the premium contribution that employers have to contribute, that employees have to contribute, depending on whether or not they participate. So you need to make sure you have a full range of accommodations so that you don't have any employees who are discriminated against based on a disability. Both sets of regulations are effective January 1st, 2017, and they apply to the first day of the plan year that occurs on or after that date. So if your wellness program plan year starts on January 1, that is the date for you to comply. If your plan year doesn't start till March or till April, then you have until March or April of 2017 to make sure that your wellness program complies. So this is the prime opportunity to take a look at your program or at any programs that you're considering implementing and seeing if there are any adjustments that need to be made to make sure that they're in full compliance with these statutes. The EEOC has been very aggressive in recent years, and notwithstanding what might happen with the election, which of course could change anything, there's no reason to believe that the EEOC is going to change course on that aggressive approach. So you're certainly well suited and encouraged to make those changes now so that you're good to go in 2017. On the whole, these regulations were a bit of a surprise to those of us who practice in this area. We were concerned that the EEOC might essentially deliver a death blow to wellness programs by completely prohibiting the use of incentives and penalties, which is going to make widespread participation very difficult. But they did not do that. And although they have restricted penalties and incentives in a fairly significant way, they have left in place a tool that still can be very, very helpful to employers on a variety of fronts in this era of health cost madness. That's all I have. Mike, I'll turn it back over to you.
Well, thanks so much, Brooke. That was a lot of great information, and thank you, everyone, for participating. If you have any questions regarding any of these new regulations, please feel free to reach out to Brooke directly, or you can reach out to IAML. We will get your questions answered for you. Again, thank you so much for your time, Brooke, and thanks to you for everyone for participating.
Thanks, Mike. Thanks, everyone. Thanks, Mike.